So just a couple case law holdings here on some couple issues that I thought were pretty important. This is the remedial construction services, the ICOM case. Here, a contractor wanted to enforce an arbitration provision between the prime contract and the direct contractor, and also enforce that against the subcontractor. Now, the subcontract agreement did not have an arbitration clause within it, although both the prime contract and the subcontract did acknowledge that the subcontract was subject to the prime contract. And you see that quite a bit. However, this court refused to enforce the arbitration provision, saying, even though the prime contract said, all subcontracts are incorporated therein, even though the subcontract said, we're subject to the terms of the prime contract, without actually having an arbitration provision within the subcontract, the court wouldn't enforce it. So the takeaway here is, if you do want an arbitration or any other type of ADR within your subcontract agreements, make sure they contain clear and concise language to submit the claim to whatever form of ADR, or in this case, arbitration, whether or not they are subject to the terms of a prime contract that may have an arbitration clause in it. And then finally, this Eisenberg Village case, this takes us back to BMP code 7099.2 about having having your qualifier properly manage your projects. This was a case where the contractor had an out-of-state RME, and so they were using his license. He wasn't supervising the project, and so there was a lawsuit, and the court found disgorgement. And it would have been subject to disgorgement under BMP 7031 for unlicensed contracting. So once you get a finding that the RME, in this case, or RMO, was not properly supervising the project, that could then lead to, well, then you're not properly licensed, and therefore disgorgement. And any funds that you've been paid would ostensibly have to be paid back to the owner. There was a little twist in this case, because the issue here actually came down to whether or not this was a penalty subject to the 1-year statute of limitations, which the court found that it was. But the point is that here's a case where they found that a contractor who was out of state, wasn't supervising the project, was made contractor essentially unlicensed, and therefore subject to disgorgement. So takeaway here, make sure your qualifier is properly managing and supervising the project.